Ladies and gentlemen, dear colleagues, I'm honored to be invited to this event. Just this year, this is my third time in Poland, so it feels like going home. So I always appreciate when I have the opportunity to visit your country. But this is my very first time in Warsaw, so I'm glad that I have the opportunity to look around. Comparing to the last presentation, I'll be a bit more abstract, and I'd like to give you some cases concerning privacy, cases that involve Hungarian legislation of jurisdiction. I was asked to have some words of GDPR and then introduce you the cases. Unfortunately, concerning GDPR, I have very little to say, because most companies, authorities, even government agencies waited with the implementation of GDPR either the very last moment or after that. So before coming here, I asked the Data Protection Agency if they had any case finished with any inquiry concerning GDPR, and the answer was a definite no. So there are some ongoing issues. They have just started investigations, but there's not a result I can share you today. And there was another problem that the national legislation concerning GDPR, who the authority responsible for the implementation and so on was missing for a long time. So neither legislation nor jurisdiction performed this GDPR project well, but we do our best to implement everything we can. So what I'm going to say is about few words of privacy. Why is it worth talking about privacy? And then two cases that was at Strasbourg court, but also had the EU aspects and some criteria that involve other states too, and one case at the EU court. So what about privacy? Well, a long time ago in a galaxy far, far away, people lived in privacy. And everyone was happy, and in the last century, when the European Convention of Human Rights and other national and supranational documents introduced privacy, their target was that the individual should be invisible, that people are free from the big brother, the state, and we have a private sphere, an intimate sphere, which is very close to human dignity. But the dark side of the force emerged, and in the 21st century we face lots of challenges concerning privacy. On the one hand, technical improvements like public cameras in public area, drones and so on, so you can hardly be invisible either in the street or public transport or anywhere. Secondly, not only the technical improvements, but our own behavior also damages privacy. So at social network and Facebook and Twitter, you can see what the dinner of your classmate was and what do you do after lunch. So I have 3 daughters, the eldest is a preteen, and I know that she shares everything what's happening, and I try to give her a few words on privacy, but she told me I was very old-fashioned. She's right. And at reality shows, when Big Brother is watching you, people surrender all their private life and have all parts of their life revealed to everyone. And if we see such shows, and if we log into Facebook, we find it obvious that we also have to share everything with others. And thirdly, there are global threats like terrorism, now migration crisis and so on. And government agencies, mostly national security agencies, say, well, this is not the time for privacy. I want to see everything because this is the only way I can protect you. And if you feel you are in danger, you do everything for your own protection. And people, societies, states are likely to give extra powers to national security agencies. So, what I see, you may say that I'm very pessimistic, but I try to be more realistic than pessimistic. So the question is that how much left of our privacy, and I'd like to answer that question with the introduction of three cases. The first one is a case at the European Court of Human Rights, which is Szabó and Vishy versus Hungary. And that was a privacy case from 2016 that stipulated the infringement, the Article 8 of the Convention on Human Rights. The background of this case was that there came a new regulation concerning the Hungarian police forces, and the Hungarian police has a special department, the so-called anti-terrorist department, and this anti-terrorist department gained competence to review anyone they think dangerous for national security purposes. And they needed, for using secret surveillance technology, surveillance, the permission of the Minister of Justice. And so, if the police thought that I am dangerous for national security, I tried to commit a terrorist attack or any serious crime or whatever, then they claimed permission from the Minister of Justice, and if the Minister permitted it, then they were free to search my house or whatever without my knowledge, of course. And well, there is no evidence that the police had ever used this competence. But on the other hand, neither it is clear that they did not use. Because the main point is that they work in secret. So they're not about to reveal if they use their power or not. And Szabó and Vishy are actually they are lecturers of ELTE University, which is 1 kilometer away from my university. But they were activists of an NGO. And first they launched a petition at the Constitutional Court of Hungary, and they referred, it was very interesting if the petition can be accepted or not. Because obviously Szabó and Vishy had no evidence that the police made anything against them, because it's a secret. But they referred that the mere possibility of being the subject of such search, such surveillance, allow them to turn to the Constitutional Court. And the Constitutional Court did accept the petition, so they decided in merits. But the outcome of the Constitutional Court decision was that a political control over the activity of secret surveillance is satisfactory. So it is enough that a minister who is responsible for the parliament and can be questioned or asked or anything is responsible for the activity of secret service. The court decision was very much debated, and Szabó and Vishy did not accept the outcome of the court's decision, so they turned to the Strasbourg court. And the Strasbourg court inquired into three very interesting issues. First, if their petition is admissible. Secondly, the ways of control. I mean, if political control is satisfactory or judicial control is required in such cases. And thirdly, if the control over secret service activity should be prior to the investigation itself, or is it a posterior control that first the secret service do what they want to do, and after that the judicial organ reviews if they used it correctly. And concerning admissibility, the Strasbourg court came to a very similar conclusion to the Hungarian Constitutional Court, and said that the mere possibility of the infringement of privacy is enough to turn to the court to accept the petition. Actually, the court's decision was quite interesting, or hardly interpreted, in the sense that they quoted that NGOs and media are watchdogs of a society, and watchdogs should have a stronger protection than other people. So it's not clear if the petition were accepted if Szabó and Vishy were not activists of an NGO. My position is that it should have been accepted anyhow. But that was, well, an obiter dicta reasoning of the Strasbourg court, so you cannot know what would have happened. It's more interesting the ways of control. It's interesting to compare the argumentation of the Strasbourg court and the Hungarian Constitutional Court. They both came to the conclusion that secret service activity must be supervised. You cannot let them work on their own, but the Constitutional Court was concerned that political control is satisfactory. Actually, in the decision, the Constitutional Court made a comparative analysis and analyzed lots of countries and how secret service agencies are supervised, and they came to the conclusion that common law countries are more like to accept judicial control, and civil law countries are more likely to have political control over their activity, and so that political control, the control of the Ministry of Justice and the parliamentary committee for this purpose are satisfactory. But the Strasbourg court said that there must be, by all means, there must be a judicial control, which can be either a court or a quasi-judicial organ, supervisory board or something, or an independent authority. That was not clear either if, in some parts of the decision, Strasbourg mentions court and some other parts mentioned independent authority. So there's a difference among the three. But there's also another difference, that a politician decides not upon legal argumentations, but upon political values, necessity, and so on. So if I'm a politician and the Secret Service comes to me and asks for permission, I decide whether it is necessary or not, because I'm responsible for that decision. Is it really a serious threat concerning national security, anti-terrorism, and so on? But if I'm a judge, then my position is that I need to decide if the Secret Service activity was legal or not. I cannot decide if it was needful, but if it was legal. And there's a difference between necessity and legality. As the solution of the case, so the Strasbourg court stipulated the infringement of Article 8. It's still not, the case has not been solved yet. There were certain drafts to solve the case. The first idea of the government was to introduce a supervising board, quasi-judicial authority, and the members of this board are delegated from courts, the government, independent bodies, and so on. But later on, they dropped this idea, and there came another idea that the authority for data protection, which is an independent authority, independent from the government, is responsible for supervising this activity. It was also questioned that whether before the inquiry or after it, but it's still not accepted. And our most recent issue in Hungary is to introduce administrative courts besides the normal court system. And if administrative courts are established, and now politicians are likely to give all possible competences to the newly introduced administrative courts, I find it possible that this competence will go to the administrative court, but no one knows yet. So that was the first case. The second case is also the Strasbourg case. This is the Hungarian Helsinki Committee versus Hungary. And that was not about Article 8, but Article 10, freedom of expression, but still has strong links to privacy. The background, Hungarian Helsinki Committee is also an NGO. And this NGO conducted an inquiry if criminal trials are satisfactory. And they examined specifically one element of the trial. In Hungary, like in many other countries, if the defendant is not able to, or is not willing to have a lawyer for his case in a serious criminal trial, then the police delegates someone to be his or her lawyer. And so there can be some better term, but so it's a delegated lawyer. And this NGO has some thoughts that delegated lawyers don't work properly. So they accept the money from the police, but they do nothing with the case. And they had another thought that police are likely to delegate a lawyer with who they have no trouble at all. So who is, well, to say, is not too much interested, not too much involved into the case. And to prove their gossips, the NGO requested data of public interest from police agencies, from 22 police agencies, and 20 out of 22 did give the requested data, so they gave the NGO a list that they were the lawyers of the cases, but 2 refused to give information, and they sued the police agencies, and national courts in Hungary stated that they are not data of public interest, or if they are data of public interest, then granting such information are against the privacy of the lawyers. So the claim was refused, and they turned to Strasbourg, and it was very interesting for Strasbourg case, because that was the very first time when Strasbourg explicitly declared that access for information is a part of Article 10, freedom of expression. Actually, the British government involved into the case, and they claimed that it's not. The British wanted to, so there was an Anglo-Hungarian community saying that freedom, access to public information is not part of freedom of expression, but we lost. And the Strasbourg court came to the conclusion that this activity is protected by Article 10. And the court, with a very clear argumentation, made difference between the delegation, who the delegated lawyers are, and the content of the lawyer-client relation, and they came to the conclusion that the lawyer-client relation is, no one has any business on this issue, but the mere fact who the delegated lawyers are of public interest, so police agencies should have given such information. But the Strasbourg court did not consider the fact that the NGO's activity in this purpose was undoubtedly against the goodwill of the lawyers. So they said that, well, delegated lawyers don't do anything. And I don't say that this should be a cause for not giving the information, but Strasbourg should have considered how they can balance privacy and the freedom of expression and the free access of information. So there are certain questions, the relation of privacy and data of public interest. And it was also interesting that Strasbourg considered deeply why the information was useful for the NGO. But if access to information is a fundamental right, it's out of question why I'm practicing this right. So it's like I want to organize a demonstration, which is part of my freedom of assembly, and courts would consider if there's a good purpose to demonstrate or not, which is nonsense. But the Hungarian Hungarian legislator made a very interesting step that they changed the procedure of delegation, and from that on, not the police, but the Hungarian lawyers bar, Lawyers Association, delegate the lawyer for the criminal trial. In practice, this does not make too much difference. But the lawyers bar is not a state organ. So it's quite obvious that any information of the lawyers bar is not of public interest. So it's a question if the problem is solved or not. And the third one is not particularly a Hungarian case, but does have Hungarian aspects. This is under EU law. You may certainly know the Data Retention Directive case. This directive obliged telecommunication companies to retain certain information for national security purposes, for criminal investigations and so on. But in the Digital Rights Ireland case, the ECJ declared that the directive infringes privacy and it is not proportional to the ends of the directive. So the outcome of the decision was that communication agencies cannot collect data without solid ground. And after that, you may also know the Tele2 case. It's Tele2 Sverige is a Swedish company, and the day after the decision of Digital Rights Ireland, this company said that, well, from now on, I'm not about to retain any data. But the Swedish national law also obliged Swedish individuals and companies to retain data in a very similar way as the directive. And it came also to the EU court, and the EU's position, the court's position was that general retention is contrary to EU law. But not only Hungary, but also some other countries, as I checked before coming here, there were 4 countries who still have, well, not the same, but a very, very similar national regulation as the Data Retention Directive. And I asked some government officers if they find our national regulation is in accordance with EU law, and they said that, well, they made some changes concerning the national legislation, and obviously they did, but this was just grammatical modifications, nothing to change in merits. So it's a question if the Hungarian regulation were challenged at some EU level, would it survive? So after that I may come to my conclusions. We need to admit that the scope of privacy shrinks and people hardly have any privacy in public area, which is a very pessimistic statement. But let me have a very historical case for that. Now I'm a bit embarrassed because I'm quoting to the British law. You are experts at that. But in